Done.
Welcome everybody to our FOIA Information Commission meeting. We're very lucky to have Russell Blair here today with us. And let me just give you a lay of the land as to how this goes. First of all, I'd like to thank Margarita Albin, who had this great idea to invite Russell from the Connecticut FOIA Commission to give us a primer on FOIA, what it is, and how elected officials and volunteers who are serving in boards, commissions, or the legislative body, how FOIA applies to them. And I'm hoping that this evening will be very instructive so that everyone can ask questions and get a better sense of what the regulations are, so that as you do your work, you understand what is required of you and how to protect yourself in the event of a FOIA inquiry. The meeting is open to all of our volunteers, so the RTM, anyone who's serving on a board and commission, department heads. So we have a lot of people in the attendee gallery. We're trying something. We're being very innovative tonight. We're going to try something which is a Q&A. So you can type in a question, and then Lauren, Margarita, and I will try, and Russell will try and answer them as they come along. And with that, I hope that this is a very informative session. I do have to say that about 10 years ago, somebody came from the Connecticut FOIA Commission and gave probably the best presentation I've ever had for a public presentation at the town hall meeting room. And I'm so glad that we have an opportunity to do it again with them. So without further ado, I would like to introduce you to Russell Blair, somebody who over the last term I've gotten to know very, very well with all of the FOIA inquiries that I was subjected to as moderator. So I look forward to having him educate all of us and tell us a little bit about FOIA. Russell, it's all yours.
And we will be recording this. We're recording this meeting and we will be posting it on the town website, and we'll let everybody know how to get to it. And with that, Russell, over to you.
Okay. Thank you, everyone. Good evening. Really appreciate you all attending tonight. There's a lot of other things that you could be doing on a Thursday night, but you're here to learn about FOIA, which is great. So my name is Russell Blair. I'm Director of Education and Communications at the FOI Commission. Before I did this, just a little bit of background, before I did this, I was a journalist for about a dozen years. So I know, local government from that vantage point. I have been at municipal meetings that stretch on and on into the night, and you're sitting there sometimes wondering, oh my gosh, why are we doing this? But you're all on boards and commissions, you're serving in important volunteer roles. Maybe you were appointed, somebody asked you to run, you get on your board or commission, and now there's all this information that's coming at you. It's about FOI, it's about Robert's rules. It's the kind of thing that sort of makes your head spin. So hopefully tonight, we cover kind of the basics. We don't expect you to leave here tonight being an FOI expert. Whenever I do these training sessions, I also like to make a note that I'm not an attorney. So the challenge with FOI a lot of times is, you find yourself on a board or commission, or you're working for the town, and you get an FOI request, and all of a sudden, you're having to read statutes and make legal interpretations, and it can be difficult. Especially because some of this stuff is very time sensitive. I get a lot of questions from people, we have a meeting tomorrow. Can we do this? Can we not do this? So it can be difficult. I just say that, to reiterate that again, you're not going to be an expert. That's okay. The commission is here, to assist. So at the end, I'll give my contact information. If something comes up tomorrow, next week, next month, next year, please reach out to the office at any point. I really try to get back to people quickly with answers because I know, you know, sometimes, you know, these are important things you need to know to do the work that you all do for the town. So whenever I do one of these presentations, I also just take a second to talk a little bit about the history of FOI, just to kind of, you know, get you in the mindset of how, you know, how we got to where we are today. If you didn't know, FOI has been the law in Connecticut for almost 50 years. So we're talking back to 1975 was when the law was passed. This was really a post-Watergate reform. Ella Grasso was the governor at the time. She had served in Congress when you know, everything went down with President Nixon, and she was worried about, you know, something like that happening in Connecticut, maybe not of that same scale, but just this idea of government secrecy. And there was a real push for transparency laws across the country. What makes Connecticut unique is that we have a really strong FOI law because we have a commission where I work, and the only thing we do is we enforce the Freedom of Information Act. We're basically like the state police for FOI. And the way we operate, just so you understand a little bit more about how it works, is if somebody feels that there's been a violation of the FOI Act, you know, the law really governs access to public meetings and access to public records. So if somebody feels that you've done something wrong about a meeting, you know, maybe an agenda wasn't posted on time, maybe somebody was denied access to a meeting, you know, in the virtual, you know, Zoom world, you know, maybe the link wasn't posted. If they have a concern about a public meeting and access to a public meeting, or if they have a concern about a records request, they make a records request and they feel that the town of Greenwich is not being prompt, or they feel that the town withholds records from them, whatever it may be, that there's redactions that aren't proper. If it's a records concern or it's a concern about a public meeting, they file a complaint with us, and we get between 600 and 700 complaints a year. And really the reason we do these training sessions is we don't need any more complaints. So we want you all to have the tools and the knowledge and the know-how to run your meetings effectively, to handle FOI requests when they come up. And I think almost more importantly than that, you know, to know that, again, you can always have resources available to you if you have a question. If you're not sure about something and it's with, you know, comes with FOI, you can talk to our office, you can talk to people in your town hall, you could talk to your town attorney, you know, there are resources available to you. So don't feel like you're ever alone. If you have to make a decision, you know, you get an FOI request, do I have to give this out? Do I not have to give this out? Questions about meetings. Again, you know, we're here to help. It can be a little complicated, but we don't want FOI to get in the way of the work that you're doing. We want you to do your work in public. You know, we want the public to be able to see boards and commissions in action, see them making their decisions, have copies of the records that the boards and commissions are using. But, you know, we hope that FOI becomes something that you know how to do it. It doesn't become overly burdensome. It doesn't get in the way of the work that you're doing, but you recognize that it's important because we want the public to be able to see, you know, their government in action and understand how government makes decisions. So the FOI law really falls into two pieces. You know, as I said earlier, it's about meetings and records. So we're going to go through the meetings piece first. If you have questions about meetings, you can put them in the chat as we're going, and then we'll take a break in the middle and we'll make sure we cover everything everyone needs to know about meetings. But really, when it comes to meetings, it's about access to public meetings. Even the name of the law is a little bit of, you know, a misnomer. It's not necessarily about information. FOI is not about unlimited information. It's about access to public meetings, and it's about access to public records. So when it comes to meetings, again, you have to allow the public to have access to your meetings, so they need to know when and where the meetings are going to be. They need to know what you're discussing at the meetings. And then they need to, you know, you need to file minutes. So if people can't make it to the meeting, they're able to see what happened at the meeting. I think it's important, you know, when we talk about meetings, to look at the definition of what's a meeting in the Freedom of Information Act, because it is somewhat specific. You know, not every single time members of a board are together or a member of a board is talking to somebody at town hall, you know, what makes something a meeting, right? You know, there's three things really that you need to be thinking about when you think of what is a public meeting under FOI. So I'll read the definition, and then you know, we'll go over those three specific things. So a meeting under FOI is any hearing or other proceeding of a public agency, any convening or assembly of a quorum of a multi-member public agency, and any communication by or to a quorum of a multi-member public agency, whether in person or by means of electronic equipment, to discuss or act upon a matter over which the public agency has supervision, control, jurisdiction, or advisory power. So again, there's really three things there. We have a quorum of a multi-member public agency is number one. Number two, in person or by means of electronic equipment. We'll talk about that more in a second, but a meeting does not necessarily have to be in person. And then number three, discussing or acting upon something that you have supervision, control, jurisdiction, or advisory power over. So the first one there, quorum, if you don't know what a quorum is, basically it's a voting majority of your board. So if you have a 5-member board, your quorum is 3. If you have 9 members, your quorum is 5, and so on. Essentially, it's enough people that could make a decision on behalf of the whole board. So if you have a quorum of your board and you're together in person or on an email chain or a text message chain, or tonight we're on a Zoom meeting, quorum, you're together. And then the last one there, discussing or acting upon a matter over which you have supervision, control, jurisdiction, or advisory power. So when you meet those 3 factors, that's a public meeting under FOI. So the public needs to be invited, and there needs to be public notice of that meeting, and you need to take minutes of that meeting. Whenever I do these training sessions, there's always a lot of concern about emails. When I say electronic meetings, people sort of say, oh my gosh, do you mean we can't email our board members? How are we ever going to get any work done? It doesn't mean that you can't have emails with a quorum of your board. It just means that the content of those emails, you want to be really careful. Again, remember the third part of that definition, discussing or acting upon a matter over which you have supervision, control, jurisdiction, or advisory power. So for example, you can send the agenda out to your entire board. That's not a problem. A board member can share, with their fellow board members information, a newspaper article that they found about something going on in town. They could share, something that they want to add to the agenda. They have a proposal they want the other board members to look at. Really, the way to think about it is you can have a one-way communication. You can share something you want the other board members to see. FYI, somebody in town contacted me about this issue. Here's the letter that they sent. I think we need to do something. Let's talk about it at the next meeting. That should always be kind of the way you're thinking about this. Is you can share information over email, you could share documents, but when you're discussing and acting upon those documents, that needs to happen at the meeting. The temptation sometimes when you have a whole board or commission on an email is people are going to start replying all. Maybe the agenda comes out and people start jumping in and they start talking about the agenda items. That's a no-no. That's what you want to avoid. You want to avoid discussions, deliberations, debates, and certainly no votes. You cannot vote over email before a meeting. Important thing to know about this, again, is the quorum is important. So this does not mean that 2 or 3 board members, if it's less than a quorum, they can talk about their positions on things. They can discuss the issues. They can talk about how they're going to vote on a matter because it's less than a quorum. So they're allowed to talk, strategy, talk anything they want about what the board is going to do. Or board members, less than a quorum of board members or an individual board member can also communicate with town staff. If they have questions about what's going on in a certain department, they can contact the department head with questions, ask for information that they want to use at a meeting. The meeting rule is not meant to prohibit you from doing the work of your board and commissions, but essentially when you have enough people to make a decision on behalf of the board and you're talking about something before the board, you want to be doing that in public. I know sometimes people don't intend to, but what can happen is if you have the quorum together, intentionally or not, you could start to be making decisions. You could start to get to a consensus. And then when it comes to the meeting, the worst thing that we want to, we hate to hear is, well, we already talked about this, on an email, or we talked about this yesterday at the coffee shop before the meeting, because then the public doesn't really have a view into how you guys are deciding to do something. They're not seeing you make your decisions. You're making your decisions in private, outside of the public meeting. And then when it comes time for the public meeting, there's not transparency. There's not the ability for them to follow along or to listen or to hear, why a particular board is making a particular decision. So those are kind of the 3 things that trigger a meeting. And then when you have a public meeting, as I, go into details about agendas and notices and all that, but there's a couple other ground rules that are important. Anyone can attend a public meeting. So, you can't limit it to people only from your town. If somebody from across the state line in New York wants to come to one of your meetings, you have to let them come. Anyone can photograph, record, or broadcast the meeting. I always say if you're at a public meeting, I would hope you don't say anything that you wouldn't want someone to record you saying, but just know somebody out in the audience at a public meeting, they could be recording the meeting. They don't need to give you a prior heads up as long as they're not being disruptive. One important thing to know about public meetings is there is no requirement under FOI or any other Connecticut law that you have public comment at your meetings. If you want to have public comment, that's great, but just know the board is in control. So public comment, you can limit how long people can speak. You can limit the agenda items. For public comment, you can ask people to give their name and address. You could not ask people to give their name and address just to attend a meeting. But if you wanted to have that requirement for public comment, that's up to you. So public comment entirely within the purview of the board. The only thing with FOI where public comment becomes an issue is that if you have hybrid meetings and you have a public comment opportunity in person, then you need to have some ability for people who are participating remotely to also have a public comment option. So that's the only time that FOI really dictates public comment. It's just we say, if you have a hybrid meeting, you need to treat the people attending virtually, equitable to the people who are in the room and have the ability for public comment. So next thing we'll talk about is the three different types of meetings that are allowed under the law and the requirements that go along with those. I have some materials I could send around afterwards, that could be sent out maybe with the presentation we have on our website. It's called our meetings grid. I would really encourage you all to take a look at that. And it goes over what we're going to talk about next, but it goes really by the type of meeting and all the different rules. So if you don't remember everything we talked about today, that's a chart that you could refer to. So I'll make sure to send that out. But what the law says is you can have regular meetings, you can have special meetings, or you can have emergency meetings. A regular meeting is a meeting that's on your regular meeting schedule. So every board and commission, in every town should file a regular meeting schedule with your town clerk. And this basically just says, these are our meetings for the year. We're going to meet every other Tuesday at 7 o'clock. We're going to meet the first Wednesday of the month at 5 o'clock. Whatever it is, that's your regular meeting schedule. A special meeting is any time you deviate from that regular meeting schedule. The name is a little misleading sometimes. I think people see special. I've had board members call me and they say, well, can we do this at a special meeting? Sometimes members of the public see special meeting and they think it's going to be something big is going on. I better make sure I show up. It's a special meeting. All it means is just it's not on your regular meeting schedule. So it could be that there was a snowstorm. You had to move the date of the meeting. It could be that you need to add an extra meeting sometimes. Boards get busy and around the budget or something like that, and you meet once a month, you need to have another meeting. You could schedule a special meeting. So special meeting is really just the timing of it. And then the other important difference with special meetings is you cannot add additional items to the agenda at a special meeting. If you did not know, in a regular meeting, at the meeting, if something comes up, the members by a 2/3 vote can amend the agenda. They can add any item that they want to discuss or possibly take action on. Sometimes, this happens where things come up in public comment. Maybe the board thinks they need to discuss it or make a decision about it right then and there. Or, you have a Monday meeting, something blows up over the weekend and you say, okay, well, we want to add that to the agenda because that board wants to talk about it at that Monday meeting. So those are the only differences between a special and a regular meeting. Agendas for both regular and special meetings need to be filed 24 hours in advance. If you have a special meeting, you need to post the agenda online as well as file it with the town clerk. The agenda for your special meeting, time, place, and the business to be transacted. And again, you cannot add any business to a special meeting agenda. So if you're doing special meeting agendas, make sure, everything on there the board wants to take up is there. And if you have new business on your agenda, if it's a special meeting, you might as well take it off because again, you cannot add any new business. Third type of meeting that's allowed under the law is an emergency meeting. As the name suggests, only in the event of an emergency. What is not an emergency? Well, I said earlier before, about how there's a 24-hour requirement for, the agenda to be filed. What's not an emergency is you forgot to file the agenda. You come in the day of the meeting, you say, whoops, we can't have our regular meeting because the agenda is not available. Let's make it an emergency meeting. You can't do that. Emergency, really means true emergency. Could be a weather emergency. We saw this during COVID, in the early days of the pandemic, towns were having emergency meetings because there were, the public health orders, were really changing on a, an hour-to-hour basis. So they were having to make decisions quickly. An emergency meeting is unnoticed and there's no agenda. So an emergency meeting is when you gather immediately because you need to do something. Really situations where if you wait 24 hours, there's going to be some kind of consequence. You can call a special meeting on 24-hour notice, and that would be, it's pretty flexible. You can also have remote meetings. We'll talk about that in a second. So there's a lot of flexibility for boards and commissions to meet, but just know there is an option to have an emergency meeting if you choose to. But if you do, again, stick to just emergency topics. Next requirement for meetings is minutes. So regular meetings and special meetings, you need to file the minutes within 7 days. Emergency meeting, minutes need to be filed within 72 hours. So again, because it's not a noticed meeting, you have less time to turn around your minutes. But for regular meetings and special meetings, 7 days for the minutes. That's really the most important thing to know about minutes. FOI doesn't really get deep into the content of your minutes. We just want to see them filed within the 7 days. Legally, you do have to record the votes that are cast at a meeting in the minutes. You need to record who is in attendance at the meeting. And if you have an executive session, you need to make sure you include who is in attendance at the executive session in that meeting. But how long your minutes are, how detailed your minutes are is not something that the commission is going to look at. Nobody can file a complaint against you because they don't like that your minutes aren't detailed enough. Nobody has a right to be included in the minutes. I know sometimes, especially when it comes to public comment, people will stand up and say, I want every word of this in the minutes, or they'll hand documents to board members, they'll ask for them to be included in the minutes. So those are things that are not a requirement. Those things may be board policy. Maybe you do attach correspondence to the minutes. That's okay, but it's not something that you have to do if somebody requests it.
Blair, give
yes.
you a breather, or Russell, sorry. We've got a couple of questions in the Q&A.
Yeah, I just saw some things with, so a couple of those, let's go through them because this is right what we're talking about. So Ken says, when it comes to minutes, 7 calendar days or 7 business days. So it depends on the type of meeting. Regular meeting is 7 calendar days. Special meeting is 7 business days. Don't ask me why they made the distinction. But special meeting, you get a little bit more time, 7 business days. Regular meeting is 7 calendar days. Somebody asked the 24-hour notice, business days only in CT, what holidays impact the 24-hour advance posting? So the way that it works with the 24-hour notice is it needs to be 24 hours where your town hall is open, where somebody could go in to view that. So, for a Monday meeting, it's got to be, before the close of business on Friday. If your town hall is closed on Friday and it's a Monday meeting, you need to get it in on Thursday. It's really meant to be, a period where people could actually go and see the agenda. FOI is a little bit of an antiquated law in some respects, and it's a requirement for physical posting. So we had a case recently where a town, put the agenda up on the website 24 hours in advance, but it was not filed in town hall. So you want to make sure all the agendas get to the clerk's office. And again, it's 24 hours where your town hall is open, so people would have the ability to go and see the agenda. Somebody asked, can people who didn't attend a meeting vote on the minutes? That's not something FOI would really take a look at. I know sometimes people abstain if they weren't at the meeting, but they could also vote on the minutes. It wouldn't matter. Is a district considered equivalent to a board of commission? District delegates covered. So I'm guessing this is an RTM thing.
This is an RTM thing,
Yeah,
maybe.
so I will say RTMs are a little bit of a blind spot for me, but I would think if you have, if you have like boards by districts or something like that, what's considered to be a public agency under FOI is, I think it sounds like potentially, if this is a, they have a sort of purview of a certain area of town or something like that. I think it would apply. I would think that, it's kind of like, to me, in my mind, it sounds a little bit like a subcommittee, which is also covered. If a board creates a subcommittee, then the subcommittee has to follow all the rules for FOI, post notices for their meetings, post agendas, do minutes and all that. So I think a district probably would be something that would be covered. You're talking about communications, we'll talk more about that, when we get to records, but typically the types of communications that would be covered under FOI, are anything dealing with board business. So if it's related to your board or commission or your district, you're talking about things, what your board is doing in response to town events or town policies or anything like that. Those are things that are available under FOI. If it's your kids are on the same soccer team and you're emailing about the soccer game, those are not public records because it's not dealing with the public's business.
There was one that kind of went to the top about the Zoom, the artificial intelligence that summarizes the meeting. I just don't know if you saw that one. It's all the way at the top.
Yeah, so let's see. Somebody actually had asked me about this. I did a training in Cornwall earlier today, interestingly enough, and they asked me about this, the very same thing. So um, I think it would depend on, if you kept a copy of that. So if you, if there's a thing ongoing where it's, doing something and doing transcripts of the meeting as it's available, and it's kind of like something, as an accessibility feature. I would say if the meeting ends and it's not there anymore, it's not something that you would have to necessarily save or provide. But I think if you saved it, if you saved that as like a transcript of the meeting or something like that, then it would be something that would be available, available under FOI. I had somebody ask me about, using that feature to do their minutes. And I said, well, you could have it transcribe your meeting, but you would still need to go back and make sure that the minutes included all the things that are legally required, that the votes are on there. It says who voted, which way, that you have the attendees, all that information. So I would, you could use it potentially, but you would have to clean it up. So I wouldn't suggest, using an AI transcript thing and just saying, okay, here are our minutes, because you still want to have somebody go through it and make sure that it has all the information and that there's not anything in there that's incorrect or misleading or anything like that. Are two agency members discussing an item before them outside of a notice meeting permissible? If it's not a quorum, they can do that because those two members cannot make a decision, on their own on behalf of the entire board. They're just two members, so they would need to bring that back to the rest of the board for them to make a decision. We have a couple questions about executive session, so we'll get to those in a second because that is coming up later. Later in the presentation. For subcommittees, is a quorum based upon the number of the main committee's voting members, or it would be the subcommittee. So if your subcommittee is 3 members of your 9-member board, then 2 members would be a quorum. So it's always based on the quorum of that particular board. So if it's a subcommittee, it's a quorum of the subcommittee. Criteria for an emergency meeting. Really, you want to be thinking about emergency meeting means just that. It means an emergency. It means a situation. What the Supreme Court has said is it needs to be a situation that was, unexpected and demands immediate action, such that if you wait 24 hours, there's going to be some kind of consequence. It's impossible for us to wait 24 hours to have a meeting because this is so pressing. So that really, it's a pretty high standard when you think about it. Most things, you could wait 24 hours. You can schedule a remote meeting. If it's an issue of getting people together, you could always say, okay, we're going to schedule a remote special meeting for tomorrow to talk about this. So there's a lot of flexibility. So emergency meetings really only, in the event of a true emergency where, time is of the essence. If we wait, longer than 24 hours, there's going to be some kind of consequence. If someone makes a mistake, as example, sends the minutes after 8 days. So if someone were to file a complaint over something like that, the commission does not tend to be very punitive. We want to work with people. We try to educate people. My guess is if it was a technical violation like that, and somebody did file a complaint, if it, it may not necessarily even go all the way to a hearing. We have an ombudsman process where we try to mediate complaints. So that seems like one where I think, we would try to resolve that, in some fashion. Maybe we go to the complainant and we say, look, okay, the minutes were a day late. The town admits it. They understand they need to do it better in the future. And maybe if for the next 2 meetings, the minutes are in on time, the person, we can negotiate the person to withdraw their complaint. So we get 600 or 700 complaints a year, but we resolve a lot of them through the ombudsman process. So, and let's say that one did go to a hearing and we did find a violation for something like that, the order would probably just be, file your minutes on time, timely in the future. We don't tend to be punitive. We have the ability to issue fines, but we really don't do it very often. Fines are really reserved for repeat offenders. The city of Bridgeport was the last agency that we fined, and it was because just repeatedly people were coming to the commission and they were having cases where they were waiting, 2 or 3 years for public records requests. So finally, the commission thought that they had to issue a fine to sort of put their foot down to say, this is unacceptable. So if it's the first time someone's before us or it's a small violation like that, most of those don't go to hearings. If they do, there's not going to be any really, severe consequences. let's see. All right, so I'm going to move on. We'll get back to some of those questions, you know, when I wrap up the meetings piece. But the next thing I want to touch on with meetings is electronic and remote meetings. What's important to know about electronic and remote meetings is that it's an option available to you. It's not a requirement. So if you want to meet in person, you can meet in person. If you want to meet over Zoom, you can meet over Zoom. What the law requires, though, is there's a few additional requirements if you have electronic meetings. Again, on our website, I'll keep plugging the website. There's a primer on there that goes into painstaking detail about all the different things that you need to do when you have an electronic or a remote meeting. But there's a couple things I just want to flag because I think they're the two biggest changes when you have remote meetings versus in-person meetings. First is if you have a regular meeting and it's either hybrid or entirely virtual, the agenda is always 24 hours in advance, but 48 hours before that meeting, you need to have the instructions on how somebody can access that meeting electronically. So that typically is going to be your Zoom link. So regular meeting, and it's on Zoom, make sure the link is available 48 hours ahead of time. The agenda still can come 24 hours, but you could, you know, post the link on the board website, post the link on your meetings calendar, just make sure the link is out there 48 hours ahead of time. Reason being is that there's additional notice required of an electronic meeting because there's some provisions that kick in where if somebody doesn't have electronic access, they're able to ask the town for assistance and things like that. So it's basically just giving people greater notice so that they know that it's going to be a virtual meeting, and then if they have questions or issues that come up, there's an extra period of time where they can try to address those. You can still have special meetings electronically on 24-hour notice, so that 48-hour rule for the link is only for your regular meetings, and it's on Zoom. And if you have an online only meeting like we're doing tonight, you know, everyone is online on the presentation. If you have an online only meeting and it's a regular meeting again, you have to record those meetings. Those are the only meetings under FOI you have to record is an online only meeting, and it's a regular meeting or a board or commission. You have to record those meetings, and then you post the recording on your website. You leave the recording on the website for at least 45 days, and the recording needs to be posted within 7 days. So it's the same time frame as the minutes, but it does not substitute for the minutes. You always do minutes. Even if it's a virtual meeting, you still have to do minutes. You can't just post a video recording and say, you know, this is the minutes. You still have to have written minutes for every meeting. And then the last thing with virtual meetings is, you know, I know we're all concerned about Zoom bombing, about people hijacking our meetings. You know, we haven't seen this as much recently. We saw it a lot early on during COVID, though. But just know the same rules apply for a virtual meeting as an in-person meeting in terms of you being able to run an orderly meeting, in terms of people acting appropriately, behaving. If somebody is being disruptive, a member of the public in a virtual meeting, you can kick them out, you can mute them, you can do whatever you need to do to regain control of that meeting, just like you would in an in-person meeting. Sometimes people get a little bolder, you know, when they're behind the screen, that they're the keyboard warriors. They're not showing their face, but if anyone's being disruptive or unruly or anything like that, you can mute them, you can kick them out of the meeting, and then there's no FOIA repercussions. So the next thing I saw, we had a couple questions about executive session, so we'll talk about that. What I think is important to know about executive session is it's really pretty limited. You know, if you look at our act, if you look at the FOI Act, there's only specific reasons you can go into an executive session. Executive session is not meant to be a place where we have conversations that make us feel uncomfortable. It's not meant to, you know, be a situation where, well, if we talk about this in public, we're going to get blowback from people, right? We want to avoid the public blowback. That's not what executive session is about. Executive session is a privilege for boards and commissions to talk about certain topics privately. And that's important to say, talk about. You're not making votes during executive session. You have to come out and take your votes in public, but you can have an executive session discussion about the following 5 things. So there's 5 reasons for an executive session. The first is for personnel matters, and personnel matters means we're talking about, you know, matters involving town employees. You know, this could be hiring somebody, this could be firing somebody, this could be a disciplinary matter involving a town employee, you know, discussion of a performance evaluation for a town employee, health matter of a town employee, anything dealing with that town employee and their status and their employment. If you have a personnel matter executive session, you need to notify the employee being discussed. You have to go tell them, you know, hey, we're having an executive session of the Board of Selectmen to talk about, you know, what happened in the Public Works Department involving you. You notify the employee, and then they have the right to request that you have an open session. So personnel executive session, notify the employee, and they can request an open session. If they request an open session, you don't have a choice. You have to have the conversation in public, even if it's uncomfortable, even if it's, you know, a disciplinary matter or something like that. You know, sometimes people want to have these discussions in public so that the newspaper can be there, so that their family can be there, colleagues can be there, whatever it may be. If they want a public discussion of their personnel matter, you have to have it in public. You can have an executive session to discuss pending claims or litigation. The important thing there is that first word there, pending. So this is, we're talking about lawsuits that have been filed. You know, a demand letter has been sent. I'm going to sue the town unless you do this. You know, a CHRO complaint's been filed, an FOI complaint's been filed. Could also be the board considering taking legal action. You know, sometimes, you know, cities and towns, you know, want to appeal a decision from a state agency. They'll sue the state agency. You know, whatever it is, it's involving some legal issue that's ongoing at that time. Third reason for an executive session is you can have an executive session to discuss a security matter if you feel a public discussion would undermine what you're talking about. You know, maybe your Board of Education is looking into purchasing new security upgrades for your schools. Makes a lot of sense if you think about it, that you might want to talk about the parameters of those security systems. You know, where are the cameras going to be? You know, where are they going to put bulletproof glass? Where are they going to put panic buttons? You know, whatever it may be. The details of that security system could be something you could talk about in an executive session. When it comes time to pay for it, you know, when you're talking about funding or signing contracts or things like that with a company, those are votes you would need to take in public, but you could discuss the parameters of that system in an executive session. Fourth reason for executive session is if you're discussing the sale or lease of property and you feel a public discussion would impact the price. You know, maybe the town is looking at purchasing some land for new athletic fields, and you've identified a location and it's listed for, you know, $200,000. Maybe the town says we can afford to spend up to $400,000 on a piece of land. You wouldn't necessarily have to discuss that publicly. You know, reveal your price point, reveal your strategy or your negotiations, you know, related to that land transaction. Because if you say you can spend up to $400,000, chances are the landowner is going to want $400,000 for the piece of land. So kind of like security, if you feel public discussion would impact the price, you could have the discussion in executive session. But when it comes time, you know, to offer, you know, make an offer, we want to move forward with spending $400,000 on that parcel. Again, you would have a public vote. And the last reason for an executive session is you can review any documents that are exempt from FOI. So we'll talk more about FOI requests in the second part, but types of things that are exempt from FOI that you may review at a meeting. It could be attorney-client privilege. Your town attorney provides you with a legal memo outlining, you know, options and, you know, involving something going on or giving their advice about how to handle a legal situation. You could go review that document in an executive session. There's also a time-limited executive session or exemption, sorry, time-limited exemption for bids. Before you award a contract, if you go out to bid, you put out an RFP, you could review the responses in executive session before you sign a contract. Once you sign a contract, you need to discuss the project in public. You need to release the bids if someone requests them. But before you sign a contract, when you're still in that negotiation phase, you haven't picked a bidder yet to award the project, you could review those documents in an executive session. You need a 2/3 vote to go into executive session, so make sure that you have the vote and that it's recorded in the minutes. You still do a notice and agenda for executive session. You still do minutes. However, your minutes do not need to include what happened in the executive session. I would say don't take minutes of executive sessions because that would be a public record that somebody could come along and request. I know some towns, when it comes to executive session, you know, they will tell people don't write anything down. You know, they'll pass out papers and then they collect them at the end. So executive session is a privilege that allows the board to meet, but there's nothing that says if you create documents based on an executive session that they're somehow exempt. So if you're on a board or commission, you go into executive session, you get home at night and you type up an email to all your fellow board members and you reveal everything that you talked about in an executive session, somebody could FOI that communication and it wouldn't necessarily be exempt. So again, executive session allows you the privilege to meet, but it doesn't necessarily mean that if you create records from that executive session that those are going to be exempt. Who can go into an executive session? That's a common question. It's up to the board or commission. You can invite in whoever you want. The important thing, though, is that the people you bring in, they should be there for a purpose, that you're asking them questions, they're giving public testimony, you want to hear their side of the story. You don't want to bring in people to the executive session that are just going to sit there in the back of the room and they're going to listen, because in that case, you're creating what we call a second audience. You're bringing in people who are just observing the executive session, and then they're getting privilege that other people, maybe members of the public would want to partake in that too. So you can bring in whoever you want, but really they should be there as a participant when you don't need them anymore, when it's time for the board to deliberate about something. Those people can leave the room, and really the executive session is meant to be for the board. I'm just going to look through the questions here. So I think we touched on some of these for executive session. Caucus. Okay, so this is the next thing I was going to talk about. So, earlier on I said those three things that trigger a meeting, right? You have a quorum, you have, you're together and you're talking about board business. Well, however, there's exemptions to that, and the biggest one is the caucus exemption. So a caucus needs to be limited to members of the same board and the same party. So a caucus, unlike an executive session, you don't want to bring in all kinds of people. Your town chairman should not be coming into your caucus unless they happen to be on that board or commission. You really don't want to be bringing a lot of staff into caucus. It's not meant to be like an executive session. A caucus, there's no limitation on what you can talk about in a caucus, and that's the challenge. And you can have a caucus even if it constitutes a quorum of your board. So, in some towns, the example I always give is New Haven. They elect their alders by district. I think they have 30 alders, and it's something like, 28 or 29, or maybe all of them are Democrats. All those Democrats on the board of alders could caucus together if they wanted to before a meeting. So it does kind of blow a hole, a big hole in the whole idea of our open meetings. But what I said, I did a training earlier today, and, I made the point that, really the spirit of FOI is for you to be making your decisions in public. So caucuses are available. But I would encourage you not to see the caucus as a way to get around public discussion. Certainly, you could use a caucus to make sure, everyone's on the same page before a meeting. You could talk about your strategy. You could talk about how the members of the same party are going to vote. They want to make sure they're unified. Maybe different people are going to bring up different points about the budget, and you want to just make sure, you kind of choreograph that ahead of time so everyone knows what everyone else is going to address. But really, when you think about it, your caucus should really be your strategy. Talking about things that are more political, a position of the party, those types of things. You should not be using caucus to, make the decisions ahead of the meeting and decide how everything is going to go. The challenge with that, as I said, is there's no limitation in the law on what you can do in a caucus. Example I'll give you is that, I was a reporter before I did this. I covered a couple Hartford City Council meetings when I worked at the Hartford Courant. And the Democrats on the Hartford City Council would caucus before the meeting, and that was where all the action happened. If you ever watched one of their council meetings, there was usually pretty limited discussion because they had talked about a lot of it ahead of time. So they're allowed to do that, but again, it's not in the interest of transparency. So I would think of caucus as more of a strategy session for members of the political party, talking more about political issues. So that's one example where you can have a quorum and you're together, and it's not considered to be a meeting. There's a few other instances where that's allowed as well. You can create a personnel search committee for executive level employees. We see this often in boards of education. Your board of education can create a search committee. They could appoint the whole board of ed to the search committee if they wanted to. When you create a personnel search committee, this is really for like your department heads, police chief, fire chief, superintendent, town manager, those types of positions. That personnel search committee doesn't need to operate under FOI. Idea being that when they make a recommendation, they're going to have to bring it back to the board that created them. So for when you hire a superintendent, the search committee can do its work, can make a recommendation, but the school board is going to vote on that recommendation. So there's going to be a point when it becomes public, and there'll be a public discussion of the candidate. So personnel search committees are not considered meetings under FOI. Caucuses are not considered meetings. Strategy sessions or negotiating sessions related to collective bargaining are not considered meetings. So, if your board of selectmen wanted to meet with the union president and talk about, where things stand with the new union contract for town hall, they could do that outside of a meeting. Again, when they want to vote on the contract or something like that, that would need to be in public, but the discussion and the strategy could be done outside of a meeting. A staff meeting of a public agency is not considered to be a public meeting. So, if you have a meeting of town hall staff talking about things going on in town, the public does not need to be noticed of those meetings or invited to attend. It's only your boards or commissions. And then the last one is what we call a chance or a social meeting. And that just means that if you have a situation where members of a board or commission, a quorum of a board or commission are together, but they're in a social setting, they're in a setting where they're not there to talk about board business, those are not considered to be meetings under the Freedom of Information Act. What you want to avoid, however, is what I call the parking lot meeting, and this happens all the time. You have your meeting at town hall, you're getting out at 9 o'clock at night, and then the board members, are standing there in the circle in the parking lot. They're all talking about what happened. Now, it's okay to blow off some steam. It's okay to vent a little bit. Oh my God, I can't believe what this person said at public comment, whatever it may be. You spend a lot of time with these people. You're at all these meetings, you're doing a lot of work together. You're going to want to maybe blow off a little steam after the meeting, and that's okay. But what you don't want to do is start having, again, deliberative discussions about the things before the board, or talking about, things that are coming up at a future meeting. Just imagine, for example, at a planning and zoning commission, there's a controversial site plan application. The developer's there, there's a public hearing, the board's talking about it, and then they say, okay, it's getting late, we're going to continue this to the next meeting. So the developer's leaving the meeting, and then he sees the planning and zoning commission standing out in the parking lot, and they're all talking together. He doesn't even need to know what they're talking about. He could file a complaint with us, and he could say, for all I know, they were talking about how they're going to vote down my project at the next meeting. So, it's an optics thing. You just want to be mindful of that. You don't really want to be seen, all the board members are together in the hallway whispering before the meeting, whispering together after the meeting. Even if you're not talking about board business, it would not be an illegal meeting. So in that example I gave, if the Planning and Zoning Commission was talking about what restaurant they're going to go to after the meeting, it wouldn't be a violation, but just the presence of that, could be enough for somebody to file a complaint, and you would have to drive all the way from Greenwich to Hartford to come to the commission hearing to testify that you were deciding, where to get pizza, and you were not talking about the site plan. So that's one thing to be mindful of, is when you're in those settings where it's not a meeting, you don't want to be talking about your board business. So that's really the most of the components of the meetings part of FOI. I'm just going to look through some of these questions here before we move on to go over a little bit with records. So is the minutes time requirement 7 days to submit them to the town clerk, to post them online, to vote on them? It's to submit them to the town clerk. Interestingly enough, there is not a requirement at the municipal level that says you have to post your minutes online at all. I'm not saying that to tell you not to do it, because most people look for them online, but the requirement for 7 days is for them to be filed. So if they get posted a week later online, it's not an issue, other than that people may be calling you asking where the minutes are. In the world of shared documents, where many members of a committee are able to share their thoughts and questions in real time, is this, or can this be considered a meeting / FOIA? I think it depends on, where the discussion is taking place. It's not something that, I'll say it's not something, I don't think we've seen this at the commission specifically, but you want to be careful. If it's real time discussion, I think that makes it a little bit closer to a meeting. It's a little different if it's something where, somebody leaves their comments on a document and then sends it to a fellow board member, like in Microsoft Word, you can leave comments in the margin or something like that. I think that would be a little different than if you were all in a document together and adding and chatting and talking about things like that. So I think it would need to be more of like a real time type of situation, but it could, that could be a meeting. I mean, there's no limit on what constitutes an electronic meeting. How many years do you have to keep FOI eligible documents? The commission does not enforce records retention laws. So this is the one where I get to tell you, you got to go look somewhere else. It's the Office of the Public Records Administrator at the Connecticut State Library. If you go on their website, they have a records retention schedule for municipalities that goes over all of that. So subject number 1 for executive session also apply to board and commission volunteers. Yes, so a board can go into executive session to discuss a personnel matter involving the board. If they're talking about appointing a new member, if they're talking about, God forbid, there's sanctions against a fellow board member, they want to reprimand one of their board members or something like that, or there's some kind of internal strife on the board, personnel can include board members as well as town employees. Same thing goes, though, that you would need to notify the person. So if you wanted to, vote to sanction one of your members, you would have to tell them. Obviously, they're on the board, so they're going to know that there's an executive session. But yes, you can do that for board members. Are you distinguishing between caucusing via text, email versus in-person Zoom caucuses? There is no distinction. So you can have a Zoom caucus, you can have an email caucus, you can have a text caucus. The challenge, though, is that if you have a text caucus or an email caucus, those are public records. So somebody could request those text messages or those emails, and they likely would not be exempt from disclosure. So if you want your caucus to stay private, kind of like an executive session, I would think you're better off if you can, doing it in person or doing it on a Zoom, something where you're not going to create a trail of what you talked about. If your caucus is over an email, all the Republicans on your Board of Ed can email together and it's not a meeting, but the Democrats could FOI those emails and they're going to see, what you were talking about. So you can have a virtual or an electronic caucus, but there's not an exemption for records created from a caucus. So the next part we're going to talk about is, freedom of information in terms of records, public records and records requests. Some of this may touch less on what you do day to day on boards and commissions. So, we may keep this part a little shorter, but again, ask questions as we're going, or if there's any other questions you have about FOI requests, I'd be happy to address some of those, at the end. The most important thing when it comes to public records in Connecticut under FOI is that that it's the definition of a public record is really quite broad. What is considered to be a public record under FOI, I'm just going to read a bit for the definition, is any recorded data or information relating to the conduct of the public's business, prepared, owned, used, received, or retained by a public agency, or to which a public agency is entitled to receive a copy by law or contract. Whether such data or information be handwritten, typed, tape recorded, videotaped, printed, photostated, photographed, or recorded by any other method. So anything that the town creates, that it keeps, that it maintains, it has a contract that it has access to, any of that dealing with the public's business is a public record. And except as otherwise provided by any federal law or state statute. So what this means is anything dealing with town business is a public record. And unless there's either an exemption within our law, we'll touch on some of those, or there's another law that says something is confidential. If it doesn't meet one of those two instances, then all records maintained or kept on file by any public agency, whether or not such records are required by any law or by any rule or regulation, shall be public records. So essentially, if the town has it or it deals with town business, it is a public record. The one thing that comes up with boards and commissions that I think is important to know is that the device the record exists on does not dictate whether or not it's a town record, a public record. So if you are texting on your personal cell phone, but it's about your board business, or you use your Gmail account, to talk about your planning and zoning business, those are public records. Now, it doesn't mean that anyone's going to get to go through and look through your emails or your text messages. It means that you have to turn those over potentially in response to a records request. So if somebody wants all the communications between, two planning and zoning commissioners, that could include emails on their personal emails. It could include text message on their personal text messages. But again, only things dealing with the commission. So if they have, their kids are on the same soccer team together, those text messages about the game or whatever are not public records because they don't deal with the public's business. Is this FOI webinar considered a public meeting? So with what we're doing today, sometimes, I do these during public meetings, but I would argue that, even if we had a quorum of a board or commission on here, we're not talking about specific Greenwich business. So, I would think that third trigger of a meeting is probably not, not really activated, right? We could have a quorum of a board on here. We are together electronically, but we're not talking about business before before the board. It would be different, if we had, we were getting into detail about, what was going on at the RTM or something like that. It would be a little bit different. But I think, general training sessions like this would not, in my view, be considered to be a public meeting. There's also a provision that says a quorum of a board can attend another properly noticed public meeting. So if your Board of Finance wants to go to the Board of Education meeting and sit in the audience and listen, they can do that, and it doesn't trigger a Board of Finance meeting as long as they're not, again, sitting in their chairs and talking about what they're going to do based on what the Board of Ed is talking about. So again, definition of public records is really quite broad. Next, we'll talk about, how people can access public records. So people have the ability to inspect public records or request copies of public records. The most important thing to know about when someone makes an FOI request, right, a request for public records, any written request for public records is considered to be an FOI request under Connecticut law. There's no special words they have to use. They don't have to use a special form. They don't have to say this is an FOI request. They don't have to cite the statute. If you get an email from somebody and they say, I would like copies of this report. I would like copies of your emails between you and the town planner. I would like, whatever it is, copy of this police report. Any written request for public records is an FOI request. And the number one important thing to know when you get an FOI request, the law requires that you acknowledge the request within 4 business days. So you have 4 days to acknowledge the request. That's not to provide the person with the records To provide the records, you want to be prompt. The law says you need to provide records promptly. I'll talk about that more in a second. But the only specific timeline in the law is you have 4 business days to acknowledge a request. So if you get an FOI request in, make sure somebody responds to the requester within 4 business days. If you don't, the law considers you've denied that request. The person could file a complaint, even if you already were starting to do, pull the files and everything. So you get an FOI request in, make sure you acknowledge it within 4 business days. And then you need to provide the records promptly. Now, what does that mean, right? You're saying to yourself, okay, what does prompt mean? Sort of helpfully, the commission years ago did this advisory opinion that we still use today. So this is what our attorneys look at. If somebody files a complaint against Greenwich and says they're not being prompt in terms of giving me my public records, these are the factors we would consider. So I ask you guys to be thinking about these things too when it comes to an FOI request. The size and scope of the FOI request, how big is the request? How many records are they asking for? Larger requests are going to take longer. We understand that. The amount of personnel time it takes to complete the request. Is this a request that's going to take, involve 3 different staff members all searching through their emails? Does your town attorney have to review things? Does your first selectman have to review things? How complicated is the request? The time constraints that your agency's under to complete other work. Maybe it's the end of the budget season and you're really busy, compiling all the numbers and everything for the budget. And maybe at that time, FOI requests are not going to be your top priority, and that's okay. But the important thing is that, FOI is a primary duty of public agencies. So there may be times when FOI work is going to slow down, but you can never, ignore it or push it off to the side. The commission does not like to see instances where somebody files an FOI request, you acknowledge it, and then you just stop responding to the person, and 5 or 6 months go by and they file a complaint with us. If you get a large request, you can always try to, chop it up into pieces, work on it, as you can, a couple hours a week, a couple hours here, a couple hours there. Somebody wants 15 different documents, and maybe you can give them 3 or 4 pretty quickly. If somebody wants a really big amount of records, a large request, you could always try to negotiate with them to narrow it. I always stress that I think communication with requesters is really important. Sometimes we get an FOI request in and, we start to get our back up a little bit. We view it as in an adversarial nature. Who is this person? Why are they asking for these records? What are they going to do with it? We start to think about that. I would encourage you not to try to not go down that road and really just look at what the request is for. What are they asking for? Do I have these records or not? Are they exempt or not? We'll talk about a couple exemptions in a minute. Really look at the content of the request and not who the requester is and not what their motive is. Somebody asked, can FOI requests be considered overly unreasonable and or harassment? There is a provision in the law where you can file with us what's called a petition for relief. You can file with us a petition for relief from a vexatious requester. The burden is pretty high for that, though. I won't lie. But if somebody's conduct does become harassing, that is concerning. Potentially, they could rise to meet that level. The statute for that says that it's not just somebody asking for a lot of records. People have a right to file as many FOI requests as they want. But if their conduct becomes, where they're belittling, they're argumentative, they're coming into town hall, they're yelling at people, they're screaming at people, they're berating people, that it's become abusive, that the behavior becomes abusive. There's a mechanism in the law where you file that petition with us, and potentially the person can be barred from making FOI requests from the town for up to a year. So there is a penalty out there for people who are what we call vexatious requesters, but the standard is pretty high. So it has to be somebody whose conduct is really, really to a level where it's unacceptable, it's antagonizing, it's bullying, those types of things. It's not just somebody who's filing FOI requests every week. People are entitled to do that. Obviously that requester maybe should understand that it might take them a while to get everything that he or she is asking for. But if it's abusive or it's become more about a vendetta or something like that, there is that provision in the law. So you need to fulfill records requests promptly. What fees can you charge for public records? There's no fees associated with requests for electronic records. So if somebody wants copies of electronic records, and you can deliver them electronically, those requests are free. If it's paper records, cities and towns can charge 50 cents a page for paper. You can also charge for any electronic storage medium that you need. If you need to purchase a USB drive to fulfill a request, if you need to burn something onto a CD or a DVD, you can charge for, it's kind of like paper, you're charging for the medium that you're using. You're not charging for staff time. that it takes you to search for the records. You're not charging for the time it takes your town attorney to redact the records. It's really just, the paper or, the disc or physical medium that you're putting the electronic records on. One important thing to know, if you estimate the cost of a request is going to exceed $20, you can ask for the person to make their payment upfront. I can't stress that enough. Really take advantage of that, especially people, if there's anyone who works in town hall that's listening. The worst thing you want to do is get some big request. Somebody wants, the building file, it's this thick, and it's 500 pages. You make all the copies, you tell them, okay, I have it ready for you. It's $250, and you never hear from them again because they don't want to pay for it. So if you estimate the cost is going to exceed $10, you can ask the person to give you a check before you start going and making the copies. So that's something, to take advantage of. A couple other important things to know. FOI requests need to be requests for copies of public records. It's not an opportunity to ask a board or commission or staff member a bunch of questions. You don't have to answer questions under FOI. Certainly, if somebody has questions, you work for the town, you want to try to help them out, that's okay. But you're not under any timeline to answer questions. If somebody doesn't like the answers to your questions, they can't file a complaint with us. You also don't need to do research or create documents that don't already exist in response to an FOI request. You're just providing copies of what you have as you keep it, as you maintain it. Really essentially, I did another training somewhere, and an attorney said, I like this. She said, it's like a carbon copy. You're basically giving them, this is what we have. You're not reformatting it. You're not analyzing it. You're not compiling things into a list. If somebody wants a list and you don't have the list, you don't need to create one. Does our office get involved in what the applicant does with the records they receive? No, there's no, once the person gets the records, there could be other ramifications, obviously, if somebody's spreading mistruths, they could be sued for libel or slander or things like that. Or if they commit some kind of illegal act based on records, that would be a concern. But, FOI really just involves the disclosure. And again, we don't look at the intention of the requester. Is not something that we consider because they don't have to state it. They're not required to tell you why they want the records. So if they're public records, they need to be made available promptly. I know we're running up on time, so I just want to quickly go through a couple of the more common exemptions to make you aware of them. And then if anyone has any questions, you could leave them in the chat, and we'll wrap those up at the end. So as I said earlier, the way FOI works is the presumption is disclosure. Unless there's either another state law that says, or federal law that says not to release something, or there's exemptions within our act. So the challenge with FOI is that there are all these state laws all over the place dealing with information that interact with FOI. The important thing to know is they always override what's in FOI. So example, Department of Motor Vehicles, you all have, maybe, or most of you maybe have a driver's license, right? I can't go to DMV and ask for a copy of your driver's license and get your driver's license with your photograph and all the information on there. It's not because there's an exemption within FOI regarding that, but there's a statute at Department of Motor Vehicles that stipulates, all the information they collect, who can get it. They can give a copy to law enforcement. They can give a copy to the federal government for certain things, but you or I cannot go FOI a driver's license. So there's all these laws all over the place. What I always say is if you work in a certain area, maybe try to get familiar with those statutes. You work in public health, you're on the public health committee. Learn about what the statutes are governing public health documents. You're on planning and zoning, learn a little bit about those documents. You work in the building department, learn about, any laws that govern building department documents, because some of those could be contrary to the things we're talking about today. But if there's another law that says it's confidential, should not be disclosed, those will always override FOI. So somebody requesting lists of emails. If you have the list, you would need to provide it, but you wouldn't be required to compile a list. So, for example, this is a real one that came up with somebody who was asking for a bunch of information about people who had applied for dog licenses in another town. If they wanted a list of everyone who had a dog license in Greenwich, if you don't have the list, you don't have to create it for them. However, if somebody wants a copy of a particular dog license, or they want a copy of an application for a dog license, those are records that you have that you would need to release, but you wouldn't need to read through records and create a list for them if you didn't already have one. So again, some of the more common exemptions in FOI. First one I'll talk about is preliminary drafts or notes. And what this is meant to cover is typically it's staff work. So if you're on a board or commission, maybe you ask your staff to create a report for you to look into something. That report could take many twists and turns. There could be things added, things subtracted. There could be different people that review it and they delete this or they add a paragraph here. before it goes to the board for action, when it still is at town hall and it's not ready for public consumption yet, it could be something that's a draft and you wouldn't need to release it. However, once that document goes to the board or commission for action, it goes on the agenda, or it goes to the first selectman for him to review it and make a decision about what to do, involving that issue. Once it's ready for decisions to be made based on it, at that point, it needs to be public, which makes sense if you think about it. We need to have access to the records that the boards are using when they make their decisions. But there could be times, maybe it's a budget situation, they're drafting the budget, they're putting, this figure in, this figure out, things are changing around, your finance director's going back and forth with your school superintendent. Potentially those things could be drafts. When it comes to drafts, though, what the law says is that you need to make a determination that the public interest in withholding that document outweighs the public interest in disclosure. So again, it's kind of a high bar to meet, but there could be instances where you say, look, we don't want to release this in its draft form because it's incomplete, it's missing information, it's going to be misleading. I've heard arguments like that from towns, and that may be something that's okay. But again, once it goes to the board for a decision to be made, it needs to be made public. The next one I'll talk about is personnel files. So this is similar to the personnel executive session. The standard is you don't have to release any information from a personnel file, town employee personnel file, if it would be an invasion of personal privacy. And the standard for that is pretty high. So, as you'll keep seeing, FOI really is very in favor of disclosure. So you don't have to release information from personnel files that would be highly offensive and not a matter of public concern. Typically, this is, records involving employees, health matters involving an employee, information about an employee's family or their home life, things that are in personnel files that really don't relate, to their employment. I did a training, for a police department recently, and they said there was something in there about like a child support payments or something like that. I'd argue that probably is not something that is, of the public's interest about the fact that this police officer was paying child support, right? It's not really pertaining to his job. However, there could be information in a personnel file that's embarrassing, but maybe it pertains to our job. Maybe we got, investigated for some kind of misconduct and we were suspended for 3 days or something like that. And, we may not want that released, but if it pertains to, the performance of a public official, public employee, those types of things are typically going to be released. If you have a privacy concern when it comes to personnel records, you think that there's an invasion of privacy potentially, somebody wants the entire personnel file for your public works director and there's all kinds of information in there about, a medical leave that he took, you go to the person whose file it is, and you would say, look, we got an FOI request for your personnel file. There's records in here that I think are an invasion of privacy. And then they have veto power. They could say, I don't want those records released. And if they say that, you don't release the record. So that's a little bit about personnel files. We already talked about preliminary drafts and notes. A lot of these are similar to what we talked about in executive session. There's a security exemption if you believe releasing records are going to pose a security risk. Somebody wants the schematics of the police station. You could say, look, we think there's a security concern here. We're not going to give it to you. It could also be that you feel fulfilling a request would put an individual in harm's way. Somebody's asking for all kinds of personal information about a town employee, and they've made it known that they're doing this, for the intent to harass this person. Maybe there's an instance where you think there's a safety concern for that employee. If you have a safety concern, what the law says is that you're supposed to go to the state police and they will review the situation and they will give you, what we call a security determination letter. So they'll review the concerns that you have, and they'll say, yes, this is a security concern. And the important reason to do that is if somebody files a complaint, the guy who wants the town hall or the police station schematics, you go to the state police, they say, nope, you don't have to give it to him. If he files a complaint, the state police would come with you to a hearing. And they would testify, based on their expertise, why they believe that there's a security concern with that FOI request. So preliminary drafts, personnel files, security records, a few other ones that come up from time to time. Attorney-client privilege. I mentioned that earlier. This could be emails between you and your town attorney. The important thing with attorney-client privilege is that you're keeping it, among the members. You're not sharing it publicly. There was a situation a couple of years ago where a member of a board started reading a letter from the town attorney at a public meeting and then tried to say it was attorney-client privilege. But, if you waive the privilege, if you start reading the letter publicly or you're talking about it, in public, it's not attorney-client privilege anymore. Another one that comes up from time to time is what we call trade secrets. And this is essentially when, public agency takes in information from a business. Maybe it's about their products, it's about their pricing. it's kind of proprietary information that they're sharing with you because you're a potential customer, that you don't have to share publicly, just because somebody FOIs it. It's a trade secret of that company. They're giving it to you for a particular purpose. You don't have to pass it along, in the form of an FOI request. So I'm not going to go through all the exemptions. In the law, there were 5 or 6, when it was passed in 1975. Now it's up to 27 or 28. So the list is ever growing. Again, you can look on our website and you can read through them there. But our view is kind of, when in doubt, give it out. If it's not something that's controversial, if it's not something that's a legal issue, if it's not a personnel file, if it's routine requests, and that's a lot of what, comes into town halls is, people want, reports, and they want building permits, and they want, zoning applications and all this kind of stuff. Most, I would say, a majority of FOI requests that come in probably do not involve a large amount of exempt records. If there are exemptions, though, absolutely, that's the ability of the town to exercise those. You can redact information if it's exempt. But again, the presumption under FOI is disclosure. So if you're redacting information or you're going to deny an FOI request, I always tell people, you can do it, but just be thinking, okay, on what grounds am I doing this? Because if the person files a complaint and you come to the commission, you want to be able to have, some kind of legal argument to make, or for your town attorney to make, pointing to a statute that says, this is where it says I don't have to give it out, or saying, this is a draft under the draft exemption of FOI. This is attorney-client privilege. This document would be a security risk. You want to have some reasonable grounds on which you're denying somebody's request. Let's see, a couple questions here. Is your office compelled to release the names of people who have made requests and what they have requested if you were asked? So an FOI request is a public record. Somebody could ask for copies of all the FOI requests that you've received. I've seen some agencies where when you submit an FOI request, they put on there, please note that, the information you give us is going to be public. When I was a journalist, it was kind of an underhanded thing that would happen occasionally is, if a reporter knew that someone else was working on a story, they could say, well, give me a copy of, the FOI request that Hearst filed, and the agency needs to give it to the other reporter. So FOI requests are public. Robert's Rules is not something that our office covers. To my knowledge, I don't really know who in the state would be the expert on that. I know there's books and things like that. I don't think there's a state agency that enforces Robert's Rules. So, good question. I get a lot of questions about Robert's Rules, but FOI does not really interact with that. You can't file a complaint if somebody, didn't second the motion or something like that. If emails are requested, are we required to notify the other people listed in those emails, and what if they object? You could notify the people listed in those emails, but they would not have a right to object. The only objection part comes is if it's involving a personnel file or similar files involving a public employee. So when it comes to a public employee's personnel file, they have a right to object, but if somebody requests, all the emails that the first selectman received from, somebody on the Board of Education, you might want to tell the Board of Education member, hey, we got a FOIA for all the emails between you and I, and we're working on compiling it, but they don't get any right to come in and say, no, don't give out those records. One important thing, kind of similar to that is, FOI is only the records you have and you keep and you maintain, so you're not obligated to fulfill requests on behalf of other agencies. So someone's asking you for something that exists at the state and you don't have it, tell them, you got to go to DPH, you got to go to DOT, or they're asking, they come to town hall and they want police records. You could tell them, you got to go to the police department, got to go to the fire department. They need to make their request with the agency that maintains and keeps the records that they're looking for. So if anyone has any other questions, please leave them in the chat. I want to make sure we leave a little time to address anything else that we didn't talk about. The other thing I'll do right now is, just so I don't forget, is let me give out my contact information. So my phone number, and this is all on the website too, but 860-566-5682 is my phone number. And then my email is just my name. So Russell, RUSSELL .Blair, BLAIR @ct.gov. And again, I can't stress enough, please contact me if you have questions. Call our office. We can talk about it. We may disagree, but I can give you my guidance, or I can find a decision potentially, you know, because that's one good thing about the commission is because it's been around for, you know, for almost 50 years. We have a lot of precedent. We have a lot of cases, you know, that you can refer to. The website, I think it's ct.gov/FOI, or if you search FOI Commission, you'll find it. Clarify the minutes, is that voted minutes? So typically the minutes that you submit, they're probably not going to have been voted on because the board usually is not going to meet within the 7 days. So you have to submit minutes within 7 days. And Jenny said draft public minute. Yeah, that's fine if you want to call them draft or you want to call them unapproved. Don't let waiting for the board to approve them get in the way of you filing them within 7 days. They need to be filed within 7 days. But you could call them draft, you could call them unapproved. You could, and if there's changes, you could always make the changes at the next meeting and reflect that in the next set of minutes. I think we got to all the questions and covered everything. But again, if anything else you want to talk about, give me a call or an email. Karen asked, do we have any material handbook guides that can share with us? Tomorrow I'll send out an email to the folks that helped organize this, and I'll include some material from our website. One good thing with our website is there's a pretty good search function. So if you go on there and you do a search for what the issue is, it may pop up with some decisions, past commission decisions on that area. So you can go on there and try to search for different types of scenarios, and maybe you'll get a hit on something that could be helpful. Or you can always call us or email us, but we do have some information on there about remote meetings and and other things. But with that, I think we're pretty much all set. I don't see any other questions that are lingering. So I really, again, thank you for all your attention, for all the good questions. FOI is important. I know sometimes it can seem like a burden, but hopefully, we sort of explained it in a way tonight where what's required of you, what's not required of you, and you can do it right. You can run your meetings efficiently. You know what to do if you get an FOI request, and it doesn't get in the way of all the important work that you're all doing for the town of Greenwich.
Russell, thank you so much for giving us your time this evening and doing such a great job and a comprehensive job of patiently answering questions and taking us through all the requirements. And we look forward to getting some additional information from you tomorrow. And I'm sure that people will not waste any time in contacting you if they need to. You may regret having given your phone number.
No, it's okay. I mean, I again, really, I want you to know the commission, we are here to help. We are not just the bad guys who come in when something goes wrong. I would like to think we can do as much as we can to try to prevent the complaints from happening. And that's really, why I like to do these sessions.
Great. Thank you very much. And I wish thanks everyone for attending. I know many of you are in the midst of budget season and we're all going to a lot of meetings. So I really do appreciate, we had about 70 attendees. So I appreciate that. And with that, we're going to end the meeting, but thank you all very much for attending. Have a good night.
Thank you. Good night.
Thank you.
Russ. Thank you very much.